Hi, I'm Brent Stafford, and this is RegWatch by RegulatorWatch.com. Today, the U.S. vaping industry finally had its day before the United States Supreme Court. Eric Heyer, the attorney representing Triton Distribution and Vapetasia, argued that the U.S. Food and Drug Administration shifted the goalposts in its evaluation of nicotine vaping products under the agency's PMTA process. We'll have commentary on today's oral arguments from vape industry attorney Greg Troutman and Jim McCarthy of the American Vapor Manufacturers Association. But first, here are some key moments from today's landmark Supreme Court session.
We will hear argument first this morning in Case 23-1038, Food and Drug Administration versus Wages and White Lion Investments. Mr. Gannon.
Mr. Chief Justice, and may it please the Court. Under the Family Smoking Prevention and Tobacco Control Act, a manufacturer may introduce a new tobacco product only with authorization from the Food and Drug Administration. An applicant must show that the marketing of its product would be appropriate for the protection of the public health, which requires FDA to take into account both the likelihood that existing users of tobacco products will stop using such products and the likelihood that those who do not use tobacco products will start using them if the product is marketed. Respondents' nicotine solutions for e-cigarettes are flavored to taste like fruit, candy, or various desserts. FDA denied their applications, concluding that respondents failed to show that their products have sufficient benefits for existing smokers to offset the serious risk that the flavors pose to attracting youth to the use of tobacco. Alone among the courts of appeals, the Fifth Circuit found FDA's reasoning to be arbitrary and capricious, but each of its 5 rationales was incorrect, and respondents barely defend any of them. Respondents were not unfairly surprised by FDA's denials. They now claim that they had no idea they needed to compare their flavored products with tobacco-flavored e-cigarettes, but their applications drew such a comparison. They just did not have sufficient scientific evidence to bear out their claim that non-tobacco flavors are, quote, crucial to getting adult smokers to make the switch, end quote. Nor did respondents suffer any prejudice from FDA's failure to look at their marketing plans. They've identified no features that FDA has not already found are insufficient to mitigate the heightened risk of youth uptake that flavored e-cigarettes pose, making the Fifth Circuit's remand to FDA a useless formality. This Court should reverse the Fifth Circuit's outlier decision. I welcome the Court's questions.
Well, in fairness to respondents, I think their argument is that the guidance were actually a moving target, that either they weren't clear or you changed the guidance as time went on.
That is their argument, Justice Thomas, but I think that the key point is that they knew from the statute that they needed to be making this comparison about what the benefits were with respect to existing smokers and weighing that against the potential costs with respect to non-smokers and attracting youth.
Do you recognize an obligation to tell people what they have to do to comply with your regulation, or do you think it's simply an obligation not to mislead?
Well, we think that in this context, the statute gave them the basic calculus that FDA was going to apply. FDA did give guidance saying that this is the way we're thinking about this right now. That was non-binding guidance. We acknowledge that we can't mislead them about that. I don't think they were misled at all. And that we can't mislead them. We can't change our approach without acknowledging that we're changing our approach and considering potential reliance interests that any applicants might have had in reliance on things that we previously said.
So you do have to give them notice about how to comply?
No, we think that we could have given no guidance, and FDA would have been applying the statutory criteria here, which has both halves of the calculus that I already said. It specifically says that they have the burden of proof, that they need to supply the evidence. It says that they have to supply evidence about whether their tobacco product, this is a quote, presents less risk than other tobacco products. That's in subsection B1A on page 5A of our appendix. They're supposed to be providing scientific data. The statute requires that. It says there should be well-controlled studies unless the FDA decides that other scientific evidence is actually sufficient in order to prove their case. The FDA's guidance was consistent with all of that. And the only thing that the Fifth Circuit said is that they thought that FDA had said that they needed a particular type of study. And we think that that's clearly not true.
Well, in the July 9 internal document, I recognize it's internal, seems to go further on the question of comparing tobacco-flavored products and the type of products that you described. It says, in particular, the evidence, this is 243 of the Joint Appendix, in particular, the evidence necessary for this evaluation would be provided by either a randomized control trial or a longitudinal cohort study. The absence of these types of studies is considered a fatal flaw, meaning any application lacking this evidence will likely receive a marketing denial order.
Yes, that is something that the July memo said. I note that even though it says fatal flaw, it says likely receive a denial order, so it wasn't even literally fatal. But that memo was withdrawn a month later. And so it did not govern the process. And the actual decision documents here make it clear that there could have been other evidence that was used to establish the thing that they knew they were trying to establish here.
Mr. Heyer?
Mr. Chief Justice, and may it please the Court, FDA's new longitudinal comparative efficacy requirement directly contradicts the guidance FDA provided before the submission deadline, when FDA knew that roughly 2/3 of adult ENDS users use flavored products. Before, FDA said, quote, no specific studies are required for an application. After, FDA denied applications for over 1 million products and over 250 applicants because they lacked a randomized controlled trial, a longitudinal cohort study, or some, quote, other evidence comparing the flavored ENDS products at issue against tobacco-flavored ENDS products as to cigarette reduction over time. Not a single applicant included these studies in their initial application. Before, FDA said applicants were free to select a comparator tobacco product and justify their selection. After, for flavored ENDS, only a tobacco-flavored ENDS product was an acceptable comparator. Before, FDA recommended single point-in-time studies on, quote, consumer risk perception and, quote, intentions. After, FDA concluded only longitudinal studies that track user behavior over time are robust and reliable. Before, FDA said it would make its determination based on the entire contents of the application. After, FDA admittedly did not assess anything in the applications beyond whether they contained longitudinal comparative efficacy evidence. Before, FDA said that a marketing plan was, quote, critical, necessary, and, quote, directly relevant to determining whether youth would be protected. After, FDA entirely ignored the marketing plans, determining that in its experience, no marketing restrictions were adequate. FDA's denial orders suffer from multiple flaws. FDA switched its position on what studies were required, and in so doing failed to consider applicants' reliance interests in the original instructions and less drastic alternatives. It ignored the marketing plans and ignored the notice and comment process mandated by the APA and the Food, Drug, and Cosmetic Act. The Court should therefore affirm the judgment below. I welcome the Court's questions.
What's the difference between the long-term studies and the randomized controlled trials and the longitudinal cohort studies? What's the difference, and why is that a change in FDA's requirements?
Sir, Honor, a longitudinal study could be of any duration, and that's the core. That's our core claim here. FDA didn't define long-term as being 6 months or more, and longitudinal studies are any study that tracks the users over time. What FDA never said in any of the guidance over the multiple years up to September 9th, 2020, is we're going to have this new comparative efficacy requirement. The word efficacy is not in the statute, and again, this case wasn't briefed or argued under Loper, but I think the previous guidance is consistent with the language of the statute, and FDA has massively changed that after the fact by rigging the weighing of the.
So we would have to agree with you that what the FDA has said here is actually something different or new than what it was saying about your need to provide scientific evidence, valid scientific evidence concerning the flavoring.
Well, it was new. There's no reference to comparative efficacy studies, and there's no evidence before the deadline, anything from FDA about the need to conduct any studies, comparative efficacy or not, for flavored products that differed from tobacco.
I mean, FDA says, look, you should think hard and you should give us materials about flavors, because that's one of the things that we're really going to be thinking about is flavors. And in your application, you talk about the role of flavors, right? That your application tries to show that if you have flavors, it's better at getting people to quit smoking, right? That's one of the points of your application. So I guess I'm not really seeing what the surprise is here or what the change is here. Like, everybody basically knows that flavors are particularly dangerous in terms of kids starting the use of smoking products. And so, the countervailing benefit might be if flavors were also particularly good at getting adults to stop smoking. And that's basically what FDA told you, and it's basically what you tried to convince FDA of. And then at the end, FDA said, you haven't convinced us. We think flavors are really bad in terms of youth smoking, and we don't think that you've shown us that they provide any special benefits in terms of smoking cessation. So I guess I just don't see where the gap is here.
Well, Your Honor, this certainly wasn't called out at all, and certainly not with the level of specificity. And I would respectfully dispute the fact that everybody knows this and everybody knows that.
Well, you know that FDA thinks that flavors, FDA has been completely upfront about this, and I think that the point, that flavors, you give people blueberry vapes, the difficulty with that, and FDA, I think, has tried to document this, is that blueberry vapes are very appealing to 16-year-olds, not to 40-year-olds.
I respectfully disagree, Your Honor. In fact, the literature review that respondents provided explained in detail that often the cessation journey for combustible cigarette smokers,
No, I'm not saying that you don't have a point of view on that question, but you knew what FDA's point of view on that question was that blueberry vapes are really problematic in terms of youth smoking.
This is supposed to be a pressure test on both sides. Is that not the best way to look at it?
It really is. And what an oral argument is the justices or the judges, in case of an appellate court, they have the written briefs. The briefs can't talk to them. And so they have questions. And so they probe the lawyers to address the nagging questions. Now, the tobacco product standard issue may not have been addressed today because I think that's a pretty clear-cut binary issue. Either you did it or you didn't do it. And that might not have been an area of their concern. The questions today focused on, again, the fair notice issue, the guidance, what the guidance said, wasn't sufficient, and what the remedy is going to look at. One way to look at it is, it's been my experience that it goes before appellate courts when the judges or justices talking about remedy, that remedy is the end game of the case. That if you've won, then what's the remedy look like? And I think Eric Hire did a good job of explaining, because there was some confusion that, well, everybody can reapply again. And so there's really no harm here, because if you grant it, it's going to be, or deny it, it's going to be the case, it's going to be the same result. And Eric did a good job pointing out that no, that's not the case, because if you send these applications back for reconsideration, the industry still has the enforcement discretion that FDA is given. Product can still stay on the market during this review process. But if you require everybody just to simply reapply again, we don't have that enforcement discretion, and it will take people off the market for the 2 to 3 years it will take FDA to adjudicate a new application.
So they use some of the language, obviously, that we've been following. They didn't say switcheroo, but really it all comes down to the switcheroo that we've talked about before in the show many times. But they seem to be tunnel focused on that.
They were. Because that was the biggest bugaboo of their concern. And if you notice, Justice Thomas right out of the gate hit that issue hard, and Justice Alito did too. And they've got a dilemma here, and I think Justice Gorsuch pointed that out, is the Chenery case. This is the Chenery 1 case, not the Chenery 2 case, that if the agency has committed an error, then the remedy is to send back to fix the error. And he was sort of said that creates a dilemma for FDA, is they're saying one thing, but they're sort of, Chenery is in the face of their argument. They would have to go back and reconsider, and is that the proper way to do that? They're not going to overrule that decision, by the way. but it focused on went for an hour and a half, and it really didn't get into some of the substantive meaty issues. And I'll say this up front for everybody who's listening and watching: if we have to reapply, or if we're going to be reconsidered going forward, Mark Anton was the former executive director of SAFATA, and he had tried to get a flavor study, a comprehensive industry-wide flavor study funded a couple years ago, and he couldn't get takers for it. I think today we have seen we're going to need that. And I told him after the argument, I says, boy, you were ahead of the curve on that. I think we're going to have to, one way or the other, we're going to have to show FDA more than what we've shown them now, that flavors are effective at moving adults off of cigarettes. The studies that were done, that Dr. Farsalinos had done, Dr. Pelosa in Italy had done, are great, but they were not randomized control. They basically were surveys, which is not the same kind of science that you got in a controlled study environment. We're going to probably have to do that. And if we do, we need to be thinking now and getting the funding for that, getting that together, because if we can get a random sample of flavors, almost like remember the flavor wheel from a couple years ago? If we do something sort of like that, where we take a composite of products, and it may be, Acme Vape Company's grape, and it may be Beta Vape Company's strawberry, and it may be a combination, that you get a composite, and we test those, and then we can bridge for other comparable flavors and do something like that. It would probably be more efficient cost-wise and time-wise to do that. I think inevitably we're going to have to show that proof. The one wild card here that none of us know, we've got a change of administration coming in a little over a month. That means there'll be a new Solicitor General, and the Solicitor General is the attorney who argues on behalf of the United States before the Supreme Court. Today we had a deputy from that office arguing. We have a new Solicitor General coming in. We have new FDA administration going to be coming in. And attitudes may be different as to the validity of the science, the validity of our arguments. And my concern is that a new Solicitor General comes in and informs the court, well, the Solicitor General, the government, we've changed our position. We now agree with the industry and with the Fifth Circuit. Where does that leave us? And that's a distinct possibility to happen.
Was there anything that was asked by the justices that concerned you?
The three liberal justices, Sotomayor, Orr, Kagan, and Jackson, were pretty openly hostile to the industry's arguments. I can't get a good read on Gorsuch. I can't get a good read on Kavanaugh, and I can't get a good read on Barrett. I think we've got the Chief and Alito and Thomas probably in our camp. I don't want to lose a case 6-3. They can decide the issue on something that wasn't even argued today. Again, as I said earlier, the arguments a lot of times are probing because they have nagging questions that aren't clear from the briefs or clear from the record as to what the outcome's going to be, or what outcome should be. And that's what they focus their questions on. It will be interesting to see what the court actually says in an opinion. They may decide this on an issue that wasn't even discussed today. It was discussed in the briefs, but not discussed at argument. And that would not be unheard of.
Now, when it came to what's appropriate for the protection of public health, I got the sense that the justices, at least some of them, were satisfied with how that is set out in the statute and how the FDA is interpreting that. Whereas I've got a problem with how they've done that.
Well, I mean, appropriate for the protection of public health, how could you be more vague? And you have to consider and weigh the benefits and risks to users and non-users. Nobody talked about today exactly, again, where that line is. How many smokers are we talking about? If you do a comparative study, is it 25% of the smokers, 10% of the smokers? Is one enough? Is it 10? Is it 100? We don't know. Nobody's ever said, and I dare say if you ask FDA, How many smokers is it? They're not going to know.
There seem to be a couple of points within the argument that Eric Heyer, who is obviously arguing on behalf of Triton and the vaping industry, there seemed to be a couple of moments where it might have been a good spot to insert the fact that teen vaping has collapsed. But it seemed like this whole process is stuck back in 2019 and 2020, and there wasn't any reality brought into the argument.
And the reason why for that is, one, he's got a limited amount of time to argue. Second, you have to look at what the playing field looked like at the time. Hindsight's always 2020. We unfortunately don't get the benefit of that reduction for purposes of determining whether FDA was arbitrary in 2019 or 2020. Now, if we have to go forward and we have to reapply again, well, guess what? All of the science that is improved, all the data that's improved will help us. Now, if we get reevaluated again, if we win the case, FDA has to look anew at these applications. It's going to have to do it through the lens of the science as it is now, through the studies, through the consumer surveys, through the youth surveys as they are now, not what they were in 2020. That would be a benefit to us. And that's something I wish that Eric had addressed further, is to stress that is the reason why you need to affirm this and force FDA to re-review is the data's changed. And the data is more favorable to the industry than it was in 2020. We've had more consumer studies done since 2020 that we didn't have then. As I talked about the comprehensive flavor study that I think is going to have to be done, like it or not, we're going to have to bite the bullet and do it if we get a reversal. Those are things that would have to be considered on a remand.
I know this is going to be a sensitive question, or maybe not, but let's see. Are you disappointed with today's oral arguments?
I won't say disappointed, because I've been doing this for a long time. I've been in a lot of oral arguments, state, federal, appellate courts in that time. And I've seen cases where you really can't walk out of a courtroom confident after an oral argument that you've won or lost. You may have gotten the crap beat out of you by the judges or justices in that argument, and you end up winning the case because they go hard after the party that they actually let prevail. I've seen cases before, actually a funny case, years ago in the Kentucky Court of Appeals, lawyer argued a case, thought he did well, and the judges had a draft opinion on the bench with him, and one of them, as they were leaving, dropped it in the parking lot, and he saw it, picked it up, and he about lost it, and he ended up losing the case. Thought he was going to win, thought he'd done really, really well, and their draft opinion was the other way. You just never know. Coming out of these, going into or coming out of these arguments, how it's going to go, how you're going to fare, and what the end result's going to be. It's unusual that happens, that you come out with a sense of, now in Triton, in the en banc oral argument, I came out and I told Eric, after that oral argument, you're going to win this case 10-6, and here's going to be the 10, here's going to be the 6. And it was as it was. This is a tougher case to figure out, because we don't know if they're going to look at and decide this case on an issue that wasn't even discussed today, which is at all possible.
Is there anything that, was really standing out, Greg, that you think should be mentioned?
Just that people should not get overly optimistic or overly pessimistic. And we have no control over what happens at this point. There's a lot of variables out there that can flip, can switch, and are unknown. And so everybody just keep doing what you're doing. And the people that are working in the advocacy end are still working the legal angles. We're still working the legislative angles. We still need to get, keep those balls in the air, as well as keep the ball in the air of getting studies done and updating research, updating science, and be prepared to move forward.
So the big oral arguments, what did you think?
Well, guardedly optimistic. both the justices pressure tested both sides of the argument, the government's case and the vape company's case. And that was to be expected. And, there was some good to pull from it and some aspects that maybe weren't that great. So I've sort of got a mixed opinion. I hate to be vague, but guardedly optimistic is my main takeaway.
What parts made you a little hesitant?
Well, it seemed clear that the justices were zeroing in on whether FDA had changed the rules in the middle of the game for how vape applications were going to be assessed. And they were not at all really focused on the statute itself. In almost entire focus of the questioning was about, did FDA make errors? Did it mislead? Did it give self-contradictory guidance? And if so, was that harmful to the applicants, to the vape companies, and what remedies should be sought? And that's interesting and important, but it's a different question than whether the statute itself, as Congress wrote it, is fundamentally unfair and gives FDA too much latitude to interpret the law, as it pleases. And so I guess I was a little bit disappointed that the justices seemed to grant so much latitude to FDA in its interpretation.
Yeah, this is around what the term that was used, the harmless error argument.
Right. Yeah. I mean, FDA is trying to say, well, hey, even if we move the goalposts halfway during the game or after the game, it doesn't really matter because those companies were going to lose regardless. So it's irrelevant. And, the vape company's attorney, Eric Heyer, argued, no, that's not irrelevant. It's the centerpiece of the whole issue. And it's not harmless because these companies are going to be bankrupted and they've already gone through an enormous legal administrative gauntlet and suffered the whole way, already. He called it punitive. And so that'll be an important dimension for the court to assess. But I was a little disappointed, I guess, that this is really the first case that the court has heard since it struck down what's called the Chevron doctrine, which was federal jurisprudence that gave agencies wide latitude to interpret the law based on their expertise. And again, the court knocked that down just 6 months ago. And here's another case where Congress wrote a vague law, appropriate for the protection of the public health, could mean anything, and just lets FDA make up on the fly how it's going to apply that. And so I was more hopeful that they would zero in on that component during the oral argument.
Yeah, it's strange because at one point, I think it was Justice Sotomayor was bringing up the language for appropriate for the protection of public health and pretty much made the statement that what's in the statute seems perfectly clear and adequate.
Right. And I think we can expect that her two fellow liberal justices, who are the ones that are regarded as liberal, and that would be Jackson, Sotomayor, Kagan, are going to share that view. They give a lot of latitude to Congress to, write laws in that sort of way. I disagree with that, and I think it could hardly be more vague. I would struggle to write a law that was less, empirically rigorous than that. How about just make sure everything turns out okay? I mean, just ridiculously obscure. And look at the 6 other justices who do not share that outlook and are much more stringent on demanding that Congress be specific when it writes laws. Even though they didn't zero in on that during oral argument, they may very well already have that in mind. They may have concluded that already. They may bring it up behind closed doors when the 9 justices meet in what's called judicial conference. So it doesn't mean that it's out of the equation, but, I think that, the public would have benefited from hearing a lot more about that today.
One of the things that struck me was kind of the attitude towards flavors that, at least some of the justices have bought into the argument that adults don't like flavors and it's not appropriate.
Yeah, and I think that may actually cut against them. I think it was Justice Sotomayor who insisted bizarrely that flavors are put into vaping in order to mask tobacco flavor, which is nonsensical and not at all how it works. And I think she also insisted at another point that it was impossible to believe that any 40-year-old could possibly like blueberry flavored vaping. I mean, I'm here, I've got flavored vaping in my business travel bag. So there's the proof against it. But that could cut both ways because that's so naive, so ignorant about how the product actually works, so demonstrably untrue that when they do get into conference, Brent, and the 9 of them are talking about the case, it may cut against them. Now, Justice Kavanaugh, by contrast, has been studying vape technology for 10 plus years. He was one of the judges on the DC circuit 10 years ago that struck down the way FDA regards vaping products at the time. So he's well familiar with FDA chicanery, knows these products inside and out, has studied the briefs. He was demanding briefs from FDA 2 years ago on these kinds of cases. So in conference, if Sotomayor or the others bring up a point like that, oh, no one could like blueberry, it's going to be so ludicrously, outside the lines that it'll be that much easier for Kavanaugh to rebuke it and expose that as a, let's just say naive viewpoint. So there was some ignorance on display, but it may cut against them in the long run.
Now, I wonder if it might have not served our side better to have explained what long-term studies are, the longitudinal studies and how much of a hindrance they are in terms of like how hard they are to get done and how expensive they are. So when the FDA says you don't need them and then changes their mind and makes them the requirement, that I think would have, helped explain that for the justices.
Yeah, and that's tough. I don't envy Eric Heyer's job. Arguing in front of the Supreme Court is extremely difficult and requires, rhetorical logic mastery. And the reality is a lot of what you're describing is in his briefs. And that argument has been made in the various federal circuits that are informing the way that the court is going to be looking at this. So it's not as though that was overlooked. It's in there. But when you make your 30-minute, excuse me, not even 30-minute, like 5-minute oral argument to the Supreme Court, you have to cut to the center of the issue and decide what to leave in and what to leave out. It's like, I don't know, making a movie trailer, I guess you could compare it to. You can't show every car chase in the trailer. So I agree with you. And look, at the onus is on the justices too. I mean, I think the way they were asking questions like that, I think one justice even just said, "Oh, I'm just asking out of curiosity." Well, as an American citizen listening in the gallery, the first thing that popped to my mind was, why didn't you do your homework? Like, what are you up there doing with your lifetime appointment and office full of clerks who are the smartest law students in the country? I mean, do you think maybe you could have read the memo before you showed up today?
So was there enough fire and brimstone, do you think, from our side? Like, I just got the sense that key stuff, like, this is a travesty of administrative procedure. This is, we shouldn't have deference to the agency, certainly with Chevron being thrown out. And what about non-delegation and these issues, which we know many of the justices are keen to move on?
Yeah, I certainly wish there was more. And, if I were in a black robe sitting up there, there would have been smoke coming out of my ears and my hair on fire. I wanted more fire and brimstone. But there was some pushback in that fashion. Notice that Justice Gorsuch, for example, zeroed in on what's called the Chenery Doctrine, which again is a kind of deference that federal agencies have long relied on to, modify the rules halfway through the procedure. He knows that's important. Another justice, I think it was Kavanaugh, brought up Chevron. And so they were touching on those aspects, and the government didn't even really try to hide behind those doctrines. Curtis Gannon, who argued the case for the government, was effectively saying, we're not relying on Chenery, we're not relying on Chevron. In fact, if you remand these applications back to the, excuse me, back to the Fifth Circuit or tell us to start over, that's no big deal.
The one thing that the government definitely didn't want, though, was it to get sent back to the agency. They made that clear. They said, oh, you send it back to the Fifth Circuit, do all these other things, but just don't send it back to us. Why was that?
Yeah, they are hoping for that outcome. And obviously they'd love to win the case across the board. But you heard him say repeatedly as they argued at the Fifth Circuit, even if you rule against us and you put these vape companies back at the beginning of the line and make them start from scratch, we're still going to reject them. So there's an arrogance there and a kind of, just institutional impunity that they're clearly relying on. Now, I don't think that's going to fly. I think when the justices get into conference, they're going to know what the Fifth Circuit, how they regarded that, which was, with outrage. And they're going to say, these guys think, they can do whatever they want. And I don't know. The government was so cavalier about that. And even though no one raised their voice or got hot under the collar at oral argument today, I still think they've got their chin stuck way far out on that.
Jim, for all of our viewers out there, then, explain exactly what a win would be, what it looks like after today.
Right. Well, I guess there's a couple different variations of winning that it could play out. Number one, the court could come down and say the way the statute was written is needs to be more precise, and that FDA cannot interpret it in this way. That'd be a pretty far-reaching opinion. Far more likely is that they're going to say, is in a win scenario, they would say FDA changed the rules in the middle of the game, acted in this arbitrary and capricious way. The way that they have set up the approval process is defunct, and they need to start over and create a process by which vape companies can apply and have a measurable, predictable, transparent process and a reasonable opportunity to get approval. And then the mildest way would be if they simply insist that the FDA hear the applications again. In other words, they can keep the same system they've got, but just start over, starting now. So those are sort of three broad scenarios of how it could unfold. And it could be, it could fall anywhere in between. I mean, it's just hard to tell. But those are the scenarios for us prevailing. I am hoping that three of the justices are going to use this opportunity to really blast FDA, and that would be Gorsuch, Kavanaugh, and Alito. You heard in their questions today how they zeroed in on legal doctrines, namely Chenery and Chevron, that have given agencies a great deal of latitude in how they interpret the law. And all three of those justices have a deep antipathy when agencies do that. And you could not find a better example of an agency acting in that way than FDA has here. What's more, several of the justices pointed out that a new administration's coming in that could enact a new policy within the agency for how this is approached. And, a strong opinion that rebuked the way FDA has done it before would give the White House a great deal of momentum and legal and, yes, moral justification to do exactly that. So those are the stars that I'm hoping will align. And I'm also really grateful that for once FDA has been held publicly accountable. I mean, these guys have been thumbing their nose at the American public, causing catastrophic economic and public health harm. And it is a testament to the fortitude and the integrity of the independent vape community that we've hauled them in front of the Supreme Court and exposed them to the American public. That counts, regardless of how it shakes out. That is a victory for the vape community, I'd say, in and of itself.